Now back to the show. This is The Law Show on CL 650.
The winner takes it all. The winner takes
Welcome back to The Law Show here on CIL 650 with ABBA singing actually a truism in law. The winner takes it all. Our guests from Lakes White LLP, John Lakes and John White. John Lakes is a solicitor. John White is a barrister. Barristers go to court, John White, and that's one of the risks of going to court under any circumstances. The winner takes it all. Frequently, a third party, the judge, or sometimes even a jury, but a judge, an impartial person who doesn't care about anything other than the facts of the case, is going to either make you a winner or a loser. All the more reason, wherever possible, not to go to court, correct?
Absolutely. You can avoid going to court by structuring your affairs so that they're not messy and there's no reason for anybody to take them to court in the first place.
Right.
You can avoid going to court by settling your disputes before they get to court while you still have some control over the process, like in a negotiation or a mediation.
Right.
But some cases just go to court because people can't settle or won't settle, and then it's up to the judge. And anything can happen in court. It's an unpredictable process sometimes.
And sometimes it isn't winner take it all. It's everybody gets a little piece, and therefore nobody's happy.
Sometimes it's a split decision.
Yeah, interesting stuff. Our guests, John Lakes and John White from Lakes White LLP in North Vancouver. We're talking wills and estates and estate planning, and on the matter of contesting a will. Suppose now the will has been read, the person has died, the executor has been appointed, the terms of the will are disclosed. And not everybody's happy, and somebody's going to challenge, going to try to vary or change the will. Who's allowed to play on that field, John White, the court guy? Who do you represent?
Well, if it's going to be a challenge to the will in the sense of varying the will, as opposed to challenging whether the will is valid,
Okay.
then you're really looking at the spouse or spouses and the children.
Okay. Those are the only people.
That's it.
The inner circle.
There's got to be a fence drawn somewhere, and so it's a limited subset of people who have the standing to seek to vary the will under Part 6 of the Wills, Estates, and Succession Act, what we call WESA.
Okay. So, John Lakes, if that's the case, if there's only this very small group of people, spouses and children. Now, we all think it's Sunday morning, we're adults, we know what spouses and children are, we think. But in law, suddenly the definition of a spouse and children is something that just isn't as certain as we think it is listening to this broadcast.
That's right. Well, correct. First of all, a legally married spouse is a spouse generally as long as they've not lived separate and apart for at least 2 years with the intention to live separate and apart.
Okay.
Now, how do you prove that? One of the issues has always been an issue. Sometimes if you've had your marriage annulled, the question is whether you were a spouse to start off with. But normally, if you're a lawfully married spouse, you know when you became married, too. Like you actually have a specific. Now, your rights as a spouse may be compromised a bit because if you've entered into a prenuptial agreement or cohabitation agreement, you may have created an obligation upon one of you passing. So even if you're the spouse, you may have agreed, well, the house can be held in trust for me, but then when I die, my husband's kids get the house or something. So there may be other agreements in place that will affect the spouse's rights. Second of all, if you're legally separated but you're a spouse, there may be certain rights you have but end on your death too.
Okay, what about a former spouse, the first wife, if you will?
Well, the former spouse, usually you're protected from unless there's some obligation you have under a court order or some sort of agreement to, for example, maybe there's a provision that you have to keep your wife as the beneficiary, ex-wife beneficiary of the cottage or something like that.
Right.
But that would be more of a breach of contract lawsuit rather than a WESA thing, because once you get divorced, you're generally, although currently in WESA it says that if you've you live separate and apart for at least 2 years with intention to live separate and apart. So if you don't have an agreement, then you would still have a claim. But the issue is whether you have the intention to live separate apart. It could be that one person may have the intention to live separate apart, and sometimes the other person doesn't. So it's not absolutely clear when you're legally married, but when you're common law, it's even worse.
Okay.
Because the problem for common law, you have to be together for 2 years. And the problem is, when does that 2 years start running? I mean, when does it stop being a series of overnight dates? When
Right.
you start living together. And the other problem with common law spouse, it means that technically you have separation when just one person decides to separate, and then you don't have that 2-year interval. And it's quite controversial, and there's some discussions about maybe changing that section. But common law, despite what maybe people think, common law is not the same as being married.
No, and this is important to identify. And by the way, gentlemen, to both of you, this WESA that you keep referring to is the Wills, Estates, and Succession Act, WESA.
That's correct.
This is the most recent estate legislation in British Columbia, John White, in place since when?
Since March 31st of last year.
My goodness, so it's only about a year and a half old.
It's brand new still as far as we're concerned. It's a complete game changer for us. There used to be a whole bunch of different separate pieces of legislation that dealt with various areas of wills. We had the Wills Act, the Wills Variation Act,
right.
the Estate Administration Act, a number of other statutes. They've all been put into one statute, which we call WESA, or the Wills, Estates, and Succession Act.
Okay.
And the courts are still deciding what some of the newer provisions of WESA actually mean, and they're going to be making those decisions for years to come.
Right. Well, kind of an exciting time, though, to be in
Absolutely.
the business, because new law is written, and therefore new cases, new interpretations, and the judges, I guess, are in the same boat that you are in terms of, well, we'll kind of make this up as we go along. Not really, but in terms of interpretation based on individual circumstances, there's a lot of uncharted waters out there.
Well, the other thing too is when you're a spouse, particularly when you're in a second marriage or you both have children from previous relations, the will may only be part of what you have to do. You may have to create a trust, perhaps. So, for example,
and this is the estate planning stuff now, right?
Because sometimes second marriages last longer than first marriages.
Right.
And so you have obligations to your spouse and to your children of previous marriage as well. So people may create, some sort of rights for the wife to live in the house as long as she wishes. But this also could be in play not only when you die, but let's say if you become mentally incompetent, if you're in a care home. So people, particularly in second marriages, really have to have this in place because they probably both have obligation to other people.
Yes.
And sometimes, WESA does not give any rights to stepchildren. So the only children that have rights are actual children itself. And, sometimes if you're in a second marriage, you've blended a lot of your assets together. So then you may need to do mutual wills as well. So because there's things that make sense, like if you leave your RSP to your wife, then there's no tax obligation.
Right.
If you leave your RSPs to your children or your estate, then all of a sudden up to 40% could go to CRA. So first, if you're in your second marriage, third marriage, I don't know what percentage divorce rate there is, but a lot of people are on more than one marriage.
Yes, definitely.
So a standalone will does not always answer all your questions.
So, John White, is this the bone of contention? Because given the limited number of people that are actually allowed to contest or fight a will or challenge a will in some way, so it's either the spouse or the children. But if there's more than one spouse and more than one set of children, this would be the warring factions pretty clearly identified?
Oh, you can get warring factions under that scenario quite easily, especially with the two sets of children, where, let's say, the children from the second marriage are given much more than the children from the first marriage.
Right.
Then, that sets the scene for a challenge. You're almost inviting that. It seems to me that if you write a will in that way, I mean, as a will maker, you can give your property to anyone you want, but the court does have, at least in this province, an ability to vary or to change how you've disposed of your assets to make sure that people like your spouse and your children are reasonably properly taken care of. And different people have different views about whether they've been properly taken care of or not, whether they've had just adequate and equitable provision under your will, and that's where we see fights under what is now Part 6 of WESA, what we used to call the Wills Variation Act.
Right, right. So if suppose now you've run a small family business, and your business partner for the entire duration has been your brother. So in the will, once the business affairs are all dealt with in very business-like fashion, then it comes down to the personal distribution of your assets and so on, and you give all of your stuff to your spouse and your children. Your brother, your business partner, your pal, is left out of any personal goodies aside from what's left of the business. Does your brother have a right to contest what you gave to your wife and children, going, hey, wait a minute, if it wasn't for me, none of that money would even be there?
Well, indirectly he may, not so much under the estate, but maybe the deceased brother's been dishonest and been taking way more out of the company than the brother has. So maybe he'd have his remedy under the Companies Act as his brother may be abusing his powers of a director of the company. But as far as the actual will is concerned, your brother could only challenge it on the basis that you could prove your brother was incompetent or under undue influence. But
one of the things that you talked about over coffee, John Lakes, was the fact that some people in making the will, and part of what Lakes White LLP does is preparing wills for clients. And you said that in some cases, John Lakes, people come to you and they identify the circumstances of their life, and yet there are some details that are, well, pretty dicey, pretty dodgy, and they don't lie. They just eliminate telling you. They're a little embarrassing or very personal, intimate stuff, and because those details aren't disclosed in the process of preparing the will, you don't know about them. How often does that happen?
Well,
where the other John in this equation ends up with the family screaming at him, going, "Wait just a second! There's nothing about us in this will, and what's going on here?"
Well, sometimes there's the second spouse doesn't know that they're actually properly married because their husband may have gone to Las Vegas and had a marriage at 22 or 23 and never bothered getting a divorce.
Right, right.
Children are a big issue because, the laws all presume that our children are either our biological children or our legally adopted children. But the problem is that just because you're on the birth registration doesn't necessarily mean you're a child. That person is your child. So you have a problem that, there used to be an act called the Legitimacy Act. It ended in 1982, but it was when you had a child born out of, remember the term wedlock?
Out of wedlock.
Out of wedlock, the wife had 1 year, the woman had 1 year to make a claim against the husband or the father to say he's the father child. If not, the father had no obligations. However, that was one of the things that changed when they brought in the Charter of Rights. So you have kids who have rights against parents they've never met because that's their biological parent. On the other hand, the man who's on their birth registration as dad may not be their biological dad, so he could turn around and cut them off out of his will as well. And then you have people donating sperm and things like that. So
it's 2015, friends. The law has changed, and so has everything else. And we're just trying to struggle to keep up with it all, right?
And with DNA, you can always discover who the real parent is.
Right, right.
And sometimes these are family secrets that nobody really wants to talk about, that perhaps maybe the sister had a child and the parents just were put on the birth registration without a legal adoption.
Right.
So, and sometimes there's people in their 40s or 50s who don't really know the truth. And so there needs to be some disclosure, and maybe sometimes these secrets come out of the closet. So,
John, have you ever been in court where a child, unbeknownst to absolutely everyone else in the room, shows up going, "Hey, wait just a minute here. I am a biological child of the deceased, and I am entitled to a slice of the pie just as much as anybody else in this room"?
Well, I've got to say I haven't encountered that one personally, but you can see how it might happen. As long as the mystery child, the child coming out of the blue, has some reason to know that they're a potential beneficiary.
Right.
I mean, one of the jobs of the executor is to let potential beneficiaries under our wills variation legislation know that the will maker has died and that they've applied for probate, so that these
So if
children
if you're going to
know.
be mentioned in the will, there'll be some advance notice of it. Then.
Well, not only if you're going to be mentioned, but if you're someone who might have rights under the wills variation legislation,
Right.
people who aren't mentioned in the will but might have the standing, like spouses, other children, then they're supposed to find out that the will's in play, and they have some time. They've got 6 months or 180 days, I should say now, from the grant of probate to apply under Section 6 of WESA, the Wills, Estates, and Succession Act, to vary the will. So they got this limited window.
Right.
But yeah, I can see how that might happen. I mean, imagine if you're the mystery child and you read in the newspaper that that the father you never knew has passed away.
Right.
Somebody could come out of the woodwork. It's possible.
But usually women know who their kids are. But let's say you've got a family that, the best friend's really the father of the child.
Mm-hmm.
Okay, so if you're advising these people, you can do one of two things. Either they can go ahead with an adoption even at this stage, or else the father, when he defines his will, he defines Jerry as his son.
Ah, and that's legal?
Well, you could do that because he's saying, well, I'm going to leave, half to Jerry.
Right.
But on the other hand, if meantime this guy they know of has gone off and made millions and doesn't have any kids, they may want Jerry still the right to say, surprise, I'm going after that. So all these stories we see on TV always have a grain of truth there. And the other thing is sometimes men don't tell these things to wives.
True.
As well.
Absolutely, yes.
So, in the 80s, there was this rage for a while where women were having children outside of wedlock without ever telling the men. And I've had clients that these kids arrive 20 years later and say, hi, Dad.
Oh, my.
It does happen. So, because there's all these children that are born out of wedlock without registered fathers, and yet somehow there's got to be fathers there.
It's
too.
an interesting that it's just the fact that you've used the term out of wedlock several times in the last few.
Yeah.
It's actually quaint now,
But
isn't it?
but even though
It's so 2015 now, isn't it?
But even the issue with having, you can have two women or two men on as birth parents as far as birth certificate doesn't necessarily mean that they are the actual legal parent unless they've gone through the adoption process.
And you thought you knew what spouses and children were. You see, you tune into the Law Show, and all of a sudden, my goodness, the horizons just keep opening and opening and opening. Our guests are John Lakes and John White, partners at Lakes White LLP in North Vancouver. We're talking wills and estate law on this episode of the Law Show on CIL 650, and we'll be right back.
There's more of the show still ahead. This is The Law Show on CIL 650.